Okay, so this is not a civics class, but we will talk about some of the things that you may have covered in your high school civics class to the extent that they're necessary to flesh out the underlying legal principles which we're interested in discussing. So we're talking about judicial review. It's part of the system of checks and balances. So you may recall there are three branches of government: the executive, which at the federal level is the president, and the military, and also the military legal actors, which would include the FBI, the CIA, and the entire Department of Justice. The legislative branch, which is Congress, and all of the administrative agencies created by Congress, and the judicial branch, which is the Supreme Court. So judicial review is the legislative branch's check on the other two branches of government. And the idea is that the court can review decisions and actions of Congress and or the executive, i.e. the president, and if they are found to be in violation of the Constitution, render those decisions or actions by the other branch, the executive or the legislative branch, unconstitutional, illegal. You have to change. All right. The interesting thing about judicial review is that it comes from a Supreme Court case, a very early Supreme Court case, Marbury versus Madison, which is interesting. The Supreme Court effectively gave itself the power of judicial review as a system of the checks and balances. All right. Let's talk about jurisdiction. Criminal, civil. The court must have a basis for jurisdiction. It's the first question that the court will answer, and the reason being is courts aren't going to bother to issue a decision if it's not binding upon the parties to the case. Why would a court or a judge issue a decision that the parties don't have to respect? They won't. All right. Now, jurisdiction can come from several different sources. It can be over the person or over the property involved in the case. The most common basis for jurisdiction is in personam jurisdiction, which really means that you live in the geographic area served by the court. In other words, if you live in Hamilton County, you're subject to Hamilton County Court system. All right. In rem, this is jurisdiction over property or over a thing. Best example is I live in Hamilton County, Ohio, but I own property in Kenton County in Kentucky, right across the river. All right. So if a landlord or I should say if a tenant or a tenant's guest is injured on my property, I can be sued in Kentucky, in Kenton County, because I own property in that jurisdiction. All right, so that's how that works. The next basis is less common, but and it kind of has a funny name, long arm statutes. This really says that if I get in my car, say if I'm a resident of Hamilton County and I get in my car and I drive to New Mexico, while there I operate my vehicle negligently and cause an automobile accident. All right. Well, since I was in New Mexico, I can be subject to jurisdiction and cause property damage, at least allegedly in that state. I can be subject to the jurisdiction of the New Mexico court. All right, so that's how long-arm statutes work, and that it exists so as not to inconvenience the New Mexico resident who was driving and was hit by me. It wouldn't be fair for them to have to come back to Ohio to sue me. So that's why long-arm statutes exist. In addition to having dispute over either the person or the property, the court also has to be able to have jurisdiction over the subject matter of the dispute. And when we think of subject matter, think of taxation, criminal law, wills and trusts. All right, those are admiralty, which is sea and international waters. Those are areas and subject matters that have specified jurisdiction for courts. All right, so courts of general jurisdiction can hear any type of dispute. All right, and that's most of your trial courts are courts of general jurisdiction. Courts of limited jurisdiction can only hear specified types of cases. So family court, is where you go for a divorce. That's a court of limited jurisdiction. Tax court, court of limited jurisdiction. Admiralty, which is seas and international waters, or I should say navigable waters, American waters. Right, that's admiralty. All right, those are courts of limited jurisdiction. All right, and in the American legal system, you often can appeal if you don't like what the decision that the court has rendered. You can appeal to a higher level. So the court of original jurisdiction is the trial court. All right, so when you think of all the stuff that you see on TV, when you watch legal dramas, the witnesses taking the stand and the judge banging a gavel and things of that nature, all of that happens in the trial court, which is the court of original jurisdiction. All right. Once that judge at trial has rendered a decision, if you disagree, you can appeal, right? And most states and the federal system have a court of appellate jurisdiction, and in that court, the court hears appeals. So that means that the trial has already taken place, and one party believes that the court made a mistake. So to be clear, the court of original jurisdiction answers questions of facts and applies them to the law. The appellate jurisdiction answers questions of law. Did the court of original jurisdiction properly apply the law to the facts? So to be clear, there is not a new trial at the appellate level. There generally won't be testimony. There won't be all of the stuff you see that makes for great TV in a legal drama. The only thing that you'll see is the court reviewing for legal errors or mistakes. In addition to original and appellate jurisdiction, there are separate court systems at the federal and state level. So every single state system has their own courts, and then there's the system of federal courts. I will say that the federal court system is a court of limited jurisdiction. Most lawsuits are properly handled in state court. So the lion's share of lawsuits are handled in state court. In fact, some attorneys don't even bother to be admitted to practice in front of the federal court system. All right? But how do you get into federal court? Well, two situations. Question involving federal law, treaty, or the U.S. Constitution. Okay, so in other words, by negative inference, if you're dealing with state law, you're not properly going to hear your case or get to have your case heard in federal court. All right, so that makes sense. The federal court answers questions of federal law. Diversity of citizenship. All right, this means that the plaintiff and defendant are residents of different states. So think back to the example I used where if it was an Ohio resident and I had driven to New Mexico and caused an accident. All right. So the first bullet point, now you keep in mind you need both to qualify for federal court under diversity of citizenship. But the first, residents of different states and a big claim. So the amount in controversy exceeds $75,000. So, in other words, if I sue and ask for $75,000 in damages, I'm not going to be admitted to federal court because it has to exceed. So if I sue and ask for 75,001 cents, then that would meet the exceeding of $75,000. All right. So that's how diversity works. We'll talk about the nerve test and how to determine when one of the parties to a lawsuit is a corporation, what state they are a resident of, and how to determine that. Because when you think about Walmart, like in reality, well, Walmart has stores in every state, but where is Walmart a citizen thereof? Right. So we'll talk about how to figure that out in class.